Brian, Joe brings up a good point here. We haven't really touched on it exactly, but let's talk about the physics of a case. As a prosecutor, thankfully, none of my homicide convictions were ever reversed. Always kept it close. Try not to introduce evidence that I thought was on the line, and in some instances, even evidence that I thought I could admit. If the case was going in real well, I chose not to do it to show those appellate courts that I was using restraint in the way I went about it. Why? Because the last thing I want to do is to be trying a case from an incident from 1997 that was tried in 1998. And to Joe's point, there's transcripts, witnesses' memories don't get better. And whenever you have transcripts, people are going to testify differently. It's a matter of human nature. That always benefits the defense, no?
Well, it can, and the opposite is true. It really, context is everything in these situations. Every time a witness says, I don't remember, I don't remember, I don't remember, I just hear the defense cash register going cha-ching, cha-ching, cha-ching. However, it doesn't mean it's going to win. It has to be material problems with his memory. When the president speaks on television about a crisis, what people remember the next morning is what he was talking about. Nobody remembers the color of his tie. And the reason why you don't remember the color of his tie is because it's immaterial. So the question here is this gentleman's memory bad on the material points, or is it strictly limited to the things that don't matter or don't matter that much? And that's what's going to move the needle for the defense or for the prosecution.
Yeah, and that's where I think a lot of times it comes down to lawyering to be able to make those, those very important points. And certainly the prosecutor will be trying to do just what you said.